All right, good afternoon, everyone. Do we know what we're Ronald Deliard? Can we address Mr. Deliard? North Broward? All right, good afternoon, Mr. Deliard.
Good afternoon.
You are before the court, and I guess this would have been on a 30-day motion. I granted up to 40 days.
Yes, Your Honor.
And so we have some information, I guess, for you at this time.
And the city did file an information within the 40 days, Your Honor.
Okay.
We made a final decision on some charges. We declined some of the other counts, and we did not make a decision at this point in time on some of the other counts one way or the other.
Okay.
On those counts, specifically, that's what we need to address today. He's entitled to an ROR on those counts. It's been more than 40 days.
Okay.
First one would be charge number 1, the armed trafficking.
Yes.
He should be he's entitled to an ROR on that count.
Okay.
Next would be number 2, the trafficking in heroin between 4 and 14 grams. He's entitled to an ROR on that count.
Okay.
I just need a moment because, Ivy, if you could help me here. Because the problem is, if you look at the docket, Your Honor, it just has the possession with intent. It never shows each count, which count is for which specific drug. For instance,
Yes.
we didn't file the possession of cocaine with intent. Ivy, do you know what count that is? With intent to sell or deliver. I think it's gonna.
That's the
No.
no. Wait.
Your Honor, I believe going by the docket, it would be 10, 11, and 12. Because it's
10, 11, and 12 possession with intent to sell, manufacture, or deliver. Okay. And those are for which drug?
cocaine,
Cocaine.
oxycodone, and hydromorphone.
Okay.
And those would be the 5 counts. We have not made a final decision as of yet on, Your Honor.
Okay.
The only other matter I'd like to address, and frankly it's for Mr. Deliard's benefit, as you see on the docket, there are 2 counts of possession of weapon or ammunition by convicted felon, 8 and 9.
Okay.
We filed 8, we merged both into 1 count.
Okay.
Originally the court set bond on count 8 at $2,000
Okay.
and $1,000 on 9.
Okay.
The jail has processed the no info on count 9, but in the system when I checked, it's showing hold for magistrate on count 8.
So
It should be
ROR.
no, it should be a $2,000 bond. We did file that count.
So 8 and 9, there was a $2,000
On
bond,
8 and then 1,000 on 9.
and you're saying that something merged.
We no infoed 9, merging it into count 8.
Okay.
And the jail's already updated that to reflect showing an ROR on count 9.
Oh, okay.
The problem is he's being held no bond hold for magistrates on 8. That bond was originally $2,000 and should be put back at $2,000.
Okay.
Okay,
All right, so we've put the $2,000 back.
Thank you.
All right. All right. So, Mr. Deliard, I know there's lots of, what was that? Oh, that we were saying a lot, but just so you know, just as you heard, there are some charges that the state has not made a determination yet, whether they're filing or not. And on those charges, which is the armed trafficking, the trafficking in heroin, you've been ROR'd on those. And then the possession with intent to sell cocaine, oxycodone, and hydromorphine, those 2, you've been ROR'd. Everything else, the information has been filed. Has he been to his arraignment already? Or is it coming up?
I think it hasn't been scheduled yet. I mean, you might want to check your judge's clerk to have it scheduled for arraignment.
Judge, I received a motion from Dale Miller,
Okay.
and it's a motion for release from custody. And his contention is that the way he has these charges lined up, that the state filed a no information or declined charges. Hold on one second here. no action was taken on 15, 16, 18, 19, and 20. So I don't know, those seem to,
Did he state the name of those charges? Because those looks like 1, 2, 3, 4, 5, but it's 5 different ones that the state is saying that they've taken no action on.
And Judge, we did no info some of the counts that Mr. Reedy's referring to. The jail's already updated.
Okay.
Everything we've no info is updated in the system, and he's not being held on those counts already.
Okay,
The only, once Your Honor signs the order that we just discussed, the only counts that Mr. Deliard will be held on are counts that we did file in information.
right, so I see 1 through 5 as delivery of heroin.
You can't really go by, when you say 1 through 5, what are you going by?
The information.
Okay.
yes, I have the information. The clerk gave me a copy.
And then 6 is possession of a weapon by a convicted felon. 7 is use of a two-way communication device. 8 is tampering with evidence. 9 is driving with a suspended license, as is 10. And then 11 is possession of drug paraphernalia. Is that correct?
If you're reading off the information, that's what it is. It really is, simply put, he's already been ROR'd on the charges we declined. The only remaining charges that weren't dealt with one way or the other are the counts that I just brought to Judge Powell's attention.
Just because the motion was filed and then the motion had, for the charges on the docket is a total of 22. Of course, they're not in sequential order, but the charges that the state has told me that they've declined from the charges on the docket, those are not reflective on the information, so that would make it correct.
Okay, I'll let, so anything that you haven't decided on or that you have declined, he's ROR'd on?
Yes, that
Okay.
will be the effect after the,
And that would be everything except the charges I just read off from the information?
yes.
Okay.
So he started out with 22, and on the information, there's only 11.
You know, I tried to explain that to Mr. Deliard yesterday, but, earlier today, but
I know.
I wasn't really sure what was going on, so.
Okay. All right, so
All right.
Mr. Deliard, you'll have to go before your division judge now to move forward on the charges that have been filed. Okay?
Okay.
All right, sir.
All right, good luck.
Excuse me, all right,
Yes?
all right, all
Okay,
right,
okay. You'll talk to Mr. Linder and Ms. Nuthi on how to write that order. She wants to know, I guess we'd have to list, I don't know. You guys will work it out.
On the order.
All right, let's go back to our first appearance docket, and we will start with Joy Vecchio.
She is in North Broward, Judge.
And Ms. Vecchio is just here for this added capias, right? Because she was here this morning.
Yes, she was, Judge.
So Ms. Vecchio, they've added a misdemeanor capias.
It's actually a municipal ordinance.
It's a municipal ordinance.
I
This
thought
says,
you pled that out.
I did, well, I handled it, didn't I?
I thought-
ROR or something?
Or ROR or whatever, or,
Yeah, I think you ROR.
I sent her to
it was
pretrial?
definitely handled.
Yeah. Yeah, no, so. All right, Ms. Vecchio, you shouldn't have been brought back for the afternoon, because we handled it because they told me about it this morning, and I said the same thing as the other charge. So
It's okay.
it remains the same, okay?
Awesome. Have a nice day.
All right, you too. Was it ROR on everything, or
I think, yeah, because you put it on pretrial.
was on pretrial on everything? Okay. All right, I just want to make sure that we don't have any. You probably already have the paperwork on this from this morning. So she was ROR to pretrial
Get a copy of the order.
on everything. Oh, okay. I'll let you handle it the way you see fit. All right, Leslie Reyes. All right. Find probable cause. Samantha Anselmo.
I believe Paul Ryan.
Take care.
She indicated to me her father's gonna be bonding her out, so I would just ask the court to leave the bond where it is.
Paul Ryan, all right, Ms. Anselmo, you're before the court on one charge of possession of cocaine. I find probable cause, you have $1,000 bond, okay?
Okay.
All right, Robert McRae,
Mr. McCray, come on up, please. Please approach the judge since you're at me.
Mr. McRae is before the court on a traffic capias, and this capias is from last year, November 21st of 2018. You did not show up for arraignment. The charge is operating without a valid driver's license.
Yes, Judge, and after speaking to Mr. McCray, he wishes to see if the state has a plea offer for him.
Okay.
Offers to withhold court costs.
Chair McCray wishes to accept the state's offer.
All right, Mr. McRae, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you to resolve your case today? Is
Do you
it-
understand the offer which was extended today? Withhold adjudication, meaning it's not a conviction and court costs. And the case is over with today. Do you understand? Yeah. Let the judge know you understand.
Yes, I understand.
All right, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No,
What was that?
no contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is a withhold adjudication and court costs. Good luck, sir. All right, who needed the Spanish interpreter?
Mr. Calderon, the next gentleman on the
Mr.
docket.
Okay,
Senor Calderon.
so you are right on time.
And there's another gentleman after Mr. Calderon that needs the services of the interpreter, and that would be Mr. Caro Garcia on page 6.
Okay. All right, so this is Ruben Calderon
Calderón,
Arevalo,
Arrévalo,
and
Arrévalo. It's okay.
he's before the court this
Se
afternoon
encuentra
for
ante el tribunal en la tarde de hoy
no proof of insurance.
por no tener prueba de seguro,
Number 2,
Y el
DUI,
segundo cargo,
alcohol or drugs.
conducir en estado de embriaguez o en drogado,
3 and 4,
Tres y
DUI
cuatro.
with damage to property or person.
conducir en estado de embriaguez con daños a la propiedad o a la persona.
And number 5 is leaving the scene of a crash involving damage to
Cinco,
property.
abandono de la zona de un accidente de tránsito con daños a la propiedad o a las personas.
All right, I find probable cause.
Encuentro causa probable o motivo fundado.
And I'll hear from the parties.
Escucharé de las partes.
Judge, Mr. Calderon
Pues
gave me
el
the
señor
phone number of his
Calderón
wife.
me dio el número de teléfono de su esposa. Me comunicaré con ella después de la sala, de la audiencia, para que pague la fianza.
Right, he has a total of
Una fianza total
$2,500.
de $2,500.
All right, Abel Garcia Caro.
Abel García Caro.
All right, Mr. Caro,
Bien, señor Caro.
you're here for an add
¿Se encuentra
charge,
hoy? For an, what, Judge?
an additional charge.
Por un cargo adicional.
This is now number 5,
Ahora sería la quinta acusación.
and it is an immigration hold.
Y es una orden de detención de la autoridad de inmigración.
It is a no bond hold
Es una orden de detención sin fianza
for the Department of Homeland Security.
que proviene del Departamento de Seguridad Doméstica.
And you will have to appear before an immigration judge on this
Deberá
charge.
usted comparecer ante un juez de inmigración.
Okay.
¿Vale?
All right. Anyone else who needed a Spanish interpreter?
¿Alguien más que necesite intérprete de español?
No one else you have me, Judge.
All right.
Thank you,
Thank
Judge.
you. Good to see you. All right. Desmond Johnson. Mr. Johnson bonded.
Bonded, Judge.
All right. I find probable cause. Terrence Welch.
Mr. Welch, come on up, please. He's approaching, Judge.
All right, Mr. Welch is before the court, charge 1, driving while license suspended. Number 2, possess, display, revoked driver's license. And number 3 is an expired tag, less than 6 months. And I find probable cause.
Judge, after speaking to Mr. Welch, he wishes to resolve this matter today.
Your Honor, from what I can tell, this would be a first for Mr. Welch. So the state's offer on counts 1 and 2 would be a withhold court cause.
Okay. All right, Mr. Welch, please raise your right hand. Do you swear or affirm to tell the truth? Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is withhold adjudication, court costs, and you have 6 months to pay your court costs. Okay? Thomas Reedy.
Mr. Reedy, come on up, please. He's approaching, Judge.
All right, Mr. Reedy, you're before the court this afternoon. Charge 1, possession of fentanyl. Number 2, possession of drug paraphernalia. Number 3, violation of felony probation. I find probable cause. And you have a $1,000 bond on 1. All right, you have a no bond hold on the violation of felony probation, so you have to go before your division judge on that. Ken Travian Knox.
Knox, come on up. He's approaching, Judge.
All right, Mr. Knox, you're before the court on 1 charge of operating without a valid driver's license. Number 2, failure to stop or remain at an accident. And number 3, leaving the scene of a crash involving damage to property. And I find probable cause.
Judge, I'm going to be requesting court consider setting a $1,000 bond on Mr. Knox's behalf. My understanding is he just got a job about 3 months ago at a company called Gutter It Up. He's making about $400 a week. Right now, though, he is homeless. He does have a mailing address, though. It's a friend of his that resides in Hollywood that he can use his address to make sure he gets future court notice, so he makes sure he comes to court. But right now, he's really kind of financially indigent, so that's why we're asking a $1,000 bond on his behalf.
One moment, Judge. Your Honor, I would note that he's on probation this year. He violated his probation in front of Judge Fine. Judge Fine ordered him to 60 days in county jail. His probation was terminated upon his completion of his jail sentence. He was released. Let's see. August 8th this year. Violation of probation 2017, that was on an attempted strong-arm robbery. Another vehicle in a strong-arm robbery in 2016. Scene. So, I mean, I do have some concerns about his future appearance in court, just following release conditions.
All right, on charge number 2, Mr. Knox has a $2,500 bond. Meister Mejias.
Mr. Mejias is approaching, Judge. Hear me?
Do you have any notes on him?
Mr. Mejias is before the court. Charge 1 is burglary, occupied conveyance, unarmed. Number 2 is petty theft, and I find probable cause for these charges. Any priors on Mr. Mejias?
Resolution of any cases? curious about anywhere, because he has the officer mentioned that he had a Tennessee ID. Your Honor, while we're looking this up, I will note I do find the specific allegations to be aggravating in nature. The victim gets in a car accident, and rather than offer assistance, Mr. Mejias takes this as an opportunity to go into his vehicle and steal cash from his car. This was witnessed. He was found in possession of the cash that was stolen from the victim's vehicle. Actually, I believe a witness to the accident actually saw him doing this. I would note locally, in no particular order, at a Palm Beach 2013 theft and resisting the recovery of property. (2012) at a Palm Beach, fraudulent use of a credit card, grand theft, dealing in stolen property, false ownership info on a pawn item, possession of controlled substance, felony level 2011, theft 2010, burglary of a structure, grand theft, dealing in stolen property 2009, 3 counts of petty theft 2008, and do you have hits out from another state? I've got it. He was arrested in Tennessee for violation of a pretrial release bond condition. Previous arrest for shoplifting and false reports. I have no disposition. I would note that despite showing he's lived here in Broward for 3 years, he was identified via his Tennessee identification card.
All right, Mr. Romero?
Just as you heard, the last time he had contact with the criminal justice system was back in 2013. He's been living in our community for the past 12 years. He lives locally here in Coral Springs. He's the sole financial provider of his household. He lives there with his fiance and 3 children. They rent, they do not own. My understanding is he's working at a place called Diane's Kitchen. He works well over 40 hours a week. He makes about $13 an hour. In speaking to Mr. Mejias, he is looking forward to having his day in court. He's contesting some of the allegations that were mentioned by Mr. Lender. I did advise him today's not the day. He will have his future court date, and at that time, he could present that sort of information. But right now, Judge, his fiance is the only person that can help him post his monetary bond, and she's not working. She's a stay-at-home mother. So we're asking for a $2,000 bond on count 1 on his behalf, Judge.
All right, based on the allegations that I have, I'm going to impose a $7,500 bond on charge 1, and on number 2, he has a $750 bond. Okay?
Just ask for no victim contact.
And no victim contact. Matthew Flash.
Mr. Flash is approaching, Judge. Come on up, sir.
All right, Mr. Flash is before the court. It's attempted murder.
Yes.
Is charge 1, and then number 2 is criminal attempt to solicit or conspire capital felony.
Yes, and Your Honor, I have no objection to an ROR in count 2 and just limit the findings, frankly, to count 1.
Okay.
Your Honor, I am going to be asking that Mr. Flash be held no bond on count 1 upon a finding of proof evident or presumption great for first appearance purposes only on attempted first-degree murder. Your Honor, I do believe that the allegations in totality do show that this was premeditated, Your Honor. There does not appear to be any allegation of provocation when Mr. Flash shot his stepfather, striking him in the face. His stepfather then ran from the scene to protect himself, at which point Mr. Flash then followed the victim to the neighbor's garage, continuing to shoot. Fortunately, the gun was malfunctioning, and he was unable to discharge the firearm additionally. But I do believe the fact that after shooting his stepfather once and then following him and continuing to shoot offers evidence that this was a premeditated act and clear intention to kill his stepfather, Your Honor. There were multiple witnesses to this incident. This was captured on surveillance, and though he could not speak because of the treatment he received for the injuries, the victim was able to relay information to the officer that prepared the affidavit, and it is contained in the probable cause affidavit.
And would object to the court making a finding of proof evident presumption great at this time. That is the highest standard of proof we have in the criminal justice system. The state has called no witnesses, introduced no evidence. They point out that there are a number of witnesses, and I believe they gave sworn statements. None of those statements have been introduced. One of the witnesses allegedly had a video surveillance of the incident. That has not been produced. No medical reports have been produced to document the victim's injury. All the state has is something they're relying on, written by an officer who did not witness the incident himself. So I would ask at this time that the court not make a finding of proof evident presumption great and set a bond for Mr. Williams, or exercise its discretion and set, I'm sorry, for Mr. Flash, and or exercise its discretion and set a bond for Mr. Flash in this matter.
All right, so based on the allegations that I have in the probable cause affidavit, I am going to make a preliminary finding of proof evident presumption great. There's the victim sustained severe fracture in his midline mandible, it says, and so they had to wire his mouth shut pending surgery. There's further allegation that while he was running, that shots were fired with his back towards the defendant, that shots were fired, and also that there were persons who saw it. They found the gun on scene, which was covered in blood. So I'm going to make that preliminary finding of proof evident presumption great, and Mr. Flash will be held no bond. This is without prejudice until he has a hearing before his division judge.
And Your Honor, just for the record, it's for attempted first-degree murder?
It's attempted. I wrote attempted.
Okay, thank you.
No.
Yeah.
Okay. And ROR on the others. Count. Jamar Williams.
Sure, President Judge May.
Mr. Williams is before the court. Charge 1 is burglary, unoccupied conveyance, unarmed. Number 2 is resisting officer without violence. Number 3 is a traffic infraction not for magistrate. I find probable cause.
Judge, Mr. Williams advised me at this time he's not working. He's currently looking for employment. He lives with his aunt. From what he advised me, his aunt is not working. He's been here his whole entire life. He's 27 years old. From what he advised me, no one's going to be able to help afford to post his bond. He's asking to be released on pretrial release.
Okay.
The state's going to be requesting a $5,000 bond and a GPS monitor. Mr. Williams, his last contact was a resisting without violence from October 21st that he pled out. He just was released from state prison September 11th of this year. That was after being sentenced to just over 17 and a half months state prison as a habitual offender on 3 separate burglary conveyances. One was committed in 2018, one 2017, and the other in 2016. He also had a burglary of a conveyance in 2015, possession of firearm or ammunition by I think it's adjudicated delinquent in 2014, loitering or prowling 2015, loitering or prowling 2014. He received a withhold on a delivery of cocaine 2010, possession of cocaine 2010, and a grand theft auto in 2010.
He's from prison in September.
September 11th of this
He
year.
pled out a case in October.
End of October, yes.
$1,000 on charge 1, and the other bonds will remain in place and no return to this location. All right. All right, let's do the misdemeanor hearing docket. We only have one person there, so Markel Beckford.
Broward judge, and he would like to resolve this matter this morning.
All right.
morning.
Good
This
afternoon.
afternoon,
Good
I'm sorry.
afternoon, Mr. Beckford. Mr. Beckford has resisting without violence. You have an offer?
Yeah, well, the offer being adjudication time served, he just needs to be advised. I'm showing he has a VOP hold out of Dade County
Okay.
on a felony VOP.
All right. So, Mr. Beckford, if you wish to resolve the case today, you can. It'll be time served, is a sentence, you'll be done. But apparently you have a violation of probation in Dade County.
Yes, ma'am.
And I don't know if this is included in your violation warrant, this charge, resisting without violence that you have here, or if it's something that's going to be added if it's not. So basically, I'm telling you, I don't know what effect pleading out this case here today will have on your Dade County case. If it will have an effect, I can't give you any advice as to that.
Okay.
So, having had that conversation, do you still wish to resolve the case today?
Yes, ma'am.
All right, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Beckford, you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contact.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck.
Thank you.
All right. All right, so we did Mr. Jellyard. So Henry McBride on the felony docket,
North Broward.
North Broward. All right, so Mr. McBride was arrested October 15th, so has the information been filed?
One moment. Yes, Judge. One count of aggravated assault, one count of possession of burglary tools was filed.
All right, and when, do we have an arraignment date for him? Scheduled?
I can check. You know his bonds have been updated.
Everything's been updated? Okay.
Yes.
All right, so, Mr. McBride, you're before the court today. They were asking, a 30-day motion was filed. The state has informed me that they have formally filed charges, the aggravated assault with a deadly weapon and possession of burglary tools. All the other charges that you initially had, the state has declined those, so now you only have 2 charges with whatever bonds are attached to those. All the other bonds are gone. Yes.
Can I say something?
Yes. Yes.
No, I ain't got, but I'm on the street. I ain't got no money to bond out. You get what I'm saying? So that's why he asked for the RR.
I get what you're saying, but I am going to deny the ROR, and you'll go before your division judge for your arraignment at this time, okay?
So what day would that be?
It hasn't been scheduled for an arraignment yet.
It hasn't been scheduled yet, but it'll be soon. All right. Lawrence Ascion,
Conti, stand right here.
denied, yes. Mr. Ascion was arrested October 15th, and has his information been filed?
It has, Your Honor. 2 counts of aggravated assault with a deadly weapon have been filed. The criminal mischief was declined. He's being held no bond on a violation of pretrial on these charges.
Okay. All right, so Mr. Ascion, the state has formally filed 2 charges of aggravated assault with a deadly weapon. And so at this time, I'm denying the ROR. You will be going before your division judge shortly for arraignment on the charges that they filed. Okay? All right.
Okay.
All right, Frank Cadet.
No problem.
Thank you. Mr. Cadet was arrested October 16th, so has his information been filed?
As Your Honor, the state filed the top count of burglary of a dwelling with battery, resisting without violence. The state declined on the burglary of an occupied dwelling. This has been updated by the jail. Checking to see if he's gotten a date for his next appearance. Not as of yet.
All right, so Mr. Cadet, the state has filed the charges, or at least they've filed the information. And so at this time, I'm going to deny the ROR. You should be going before your division judge shortly. Okay? All right, Justin Rizzo.
This BCC number is not correct on the document.
All right, Mr. Rizzo was arrested October 16th. So has any information been filed on Mr. Rizzo?
It has not, Your Honor. If I could just briefly, Madam Clerk, I just want to let you know, if you can make a note of this, I don't know if it was just a typo or it was just an issue with the data entry. Mr. Rizzo's BCCN number is 754541. It's listed as 745 in the docket. I just want to make sure that isn't continuously.
The numbers has been transposed.
Yes, ma'am. Your Honor, we have not filed an information on the charges before the court. He is entitled to an ROR on these 5 counts. I am showing he is being held no bond on some other felony counts and has a significant bond set on another trafficking amount. So it's up to Mr. Rizzo if he wants to exercise his right to the ROR at this time or not.
All right.
Mr. Rizzo, it's up to you. You're still going to be held no bond because they did file one of the trafficking charges in time, and that was the trafficking in methamphetamine, I believe. The trafficking in fentanyl was no info. If you want, the judge will grant the motion to ROR you on 1, 2, 3, 4, 5 possession charges You'll stop getting credit for time served on those cases or on those charges, but you are entitled to be released on those charges if you want to.
Does my bond get reinstated for the previous charges for the arrest 3 months ago?
That you'll have to go in front of your division judge to determine.
Okay. Can I come back in a week and because I don't have any counsel right now. I don't want to make a bad decision.
Oh, that's your attorney talking.
Okay. Oh, that's my attorney. Okay.
Well, he's from the public defender's office.
That's right. I'm the one you spoke to before court, Mr. Rizzo. And I know it's kind of a confusing decision, but if you opt to be released on these 5 charges, you will not be released from jail. You have to go in front of your division judge to discuss your bond on those charges. You are entitled to be released, but if you do ask the court to release you on those charges, then you will stop getting credit for time served on those charges only, because legally you will no longer be in custody on those charges.
Could I ask it to be readdressed at a later time, or do I have to make the decision now?
You can go in front of your division judge, sure.
And then ask the ROR then?
You can.
Okay. Okay. Now my other question was: the trafficking methamphetamine was that filed? Is there a warrant number?
I'm sorry. Which one?
Was the trafficking methamphetamine was that filed? The one from the arrest 33 days ago?
Check.
Mr. Linder, do you have an answer for that question? I don't have his information in front of me. Oh, wait, maybe I do.
Yes, there's 3 separate trafficking, actually, from what I can tell, total of 4 trafficking charges that have been filed.
Okay. So yeah, I guess I just don't want to be ROR.
All right, I'll deny the ROR at this time, okay? All right. Destiny Barnes.
She's before you this morning, Your Honor, and she refused to attend.
This is one of those situations, Your Honor, when someone gets medically reset so many times that their second look ends up catching up to their actual first appearance.
So did we do something with the first appearance?
You kept the bond at $750. She had a violation of pretrial on a separate felony prostitution matter earlier this year.
All right, so we'll deny the ROR at this time.
It's too bad because I wanted to tell her something, but if she doesn't want to come to court, I guess I can't tell her. So.
Right. All right, Ellis. Thank you, Deputy. Ellis Ladson.
He's here at Main, Judge.
Good morning, Mr. Judge.
Good afternoon, Mr. Ladson. Mr. Ladson was arrested November 13th.
Yes, he appeared before Your Honor on Thursday the 14th. He's got a $3,125 bond on this case. From what I can tell, the information showing his residence is in Jacksonville, and I can tell you, Your Honor, you did sign an order recommending him or referring him to SAP in the jail.
And Judge, that is correct. If you recall, he came down here. He was the gentleman that wanted to address the court in which he was candid. He came down here to basically attend his brother's funeral, who just passed away. It was really a bad time for him. My understanding, speaking to him, he was clean for a while, and then unfortunately, you don't say anything. Unfortunately, because of that loss, he tried to find some way to cope with it. Having said that, Judge, he's going to be staying down here in South Florida. He did advise me that somebody did advise him that he's going to be able to seek employment here. He's going to try and get on his feet, but right now there's no one that can help him post his monetary bond. Judge, he's asking to be released on pretrial with random drug testing on these nonviolent offenses. Not about the facts.
Judge, I made a mistake, and
Not talking about the case means not confessing to the charges.
I want to better my life. I moved here to better my life, and I want to continue.
I think that's what you said the last time, which is why you asked for SAP, because And I granted that, so I think that's probably a place for you to start. Because it's that you came to your brother's funeral, but now you're going to be living in Broward. So now, we've gone from one extreme to the next. And so I'm gonna deny any ROR at this time. And if you really mean that you're ready to change your life, it'll be a start. That'd be a starting place for you. Okay.
What is a SAP, Miss? What is SAP?
It's substance abuse program. All right, Sean Charest.
He bonded, Judge.
Bonded?
He bonded, did he?
Did he?
Because I checked, I didn't see that
no,
he had
Mr.
posted.
Charest is here.
Let me double check.
Put it this way, if it happened very recently.
Oh,
Okay.
no, it's not showing that he posted bonds? All right, well, all right, so Mr. Charest was arrested November 13th.
Runner found property.
Oh, I'm sorry.
No,
This was attempted burglary?
Yes, $2,500 bond on attempted burglary.
It's a similar situation like somebody else earlier.
Yes, exactly. Your Honor, one moment.
Judge, while Mr. Lunder looks,
Yeah, that's fine.
Sure he is homeless. However, he just started a new job at Pace Setters. Now, my understanding, Judge, is he does have family that reside in Alabama, but their financial resources are limited. If the court's not inclined to grant a pretrial release, he's asking if the court would be inclined for a bond reduction from $2,500 to $1,000 on this offense.
I think the court based the bond on his criminal history. About a little over 5 months ago, he had a trespass, and that was on his mother's residence. 2 weeks before that, loitering and prowling. 2018, tampering with evidence and cocaine. 2018 theft. Another theft in 2018, loitering and prowling in 2018. As far as Broward, going back to 2012, dealing with stolen property and grand theft. Then 07, burglary of a structure and 2 counts of burglary conveyance. I can tell you. Let's see what's going on here. Do you have the PC, Your Honor? Okay, then I don't need to.
Looks like his charge, there's one attempted burglar, but looks like so there is, someone reported that his ring surveillance camera footage from the residence at 8421 Northwest 47th Place, and he observed the white male attempting to open the front passenger door of his vehicle. Oh, that's a different date. Is that a different date? October 2nd and then October 17th. There was another report. Then November 13th is when in a different area, 8371 Northwest 37th Street in Sunrise. All right, I am going to deny the ROR. He's gonna, he still has his $2,500 bond.
That was my mistake. I was looking at something else.
That's okay. All right, thank you, everyone. I believe that's it for our afternoon docket. All right,
I believe so.
I'll see everyone tomorrow morning.
Sounds good. All right, have a lovely evening, everyone.